The first case is Fisher versus University of Texas at Austin. If this case sounds familiar, that's because you've heard about it before. A few years ago, the court heard oral arguments in Fisher, and then a few months later, kicked the case back down to the lower courts in a very anticlimactic decision. Well, the university won once again in lower courts, and now the decision is back before the Supreme Court. So the issue here is, does the 14th Amendment's Equal Protection Clause prevent the use of race by the University of Texas at Austin in its undergraduate admissions program? The university says it's using race in a holistic manner in an attempt to create a, quote, critical mass of underrepresented minorities on campus. Abigail Fisher, the young woman challenging this provision, argues that the university's actions violate her rights under the 14th Amendment. And what the Supreme Court is going to do is going to say, A, is the school's use of race narrowly tailored to achieve a compelling government interest, and also is the school's use of race a compelling government interest in and of itself? Judging by the current makeup of the court and the fact that the court has agreed to hear this case again, then affirmative action in public universities' undergraduate admissions is in trouble. The second big case I'm watching is called Friedrichs versus California Teachers Association. This is a challenge to the legal privileges enjoyed by public sector unions, specifically teachers' unions in California. The case is even more important than that because at issue is the survival of a very important Supreme Court precedent known as Abood, coming out of Michigan in 1977. And what Abood said was that teachers' unions could either require membership or require non-members, public school teachers, to pay a fee, which is the equivalent of union membership. What's going on in this case is a school teacher in California is objecting to this regime, arguing that by being compelled to pay the equivalent of union dues, she's being forced to subsidize political speech as a condition of employment, political speech that she disagrees with. The third case I'm watching is called Luis versus United States. Now, this case may not be on everyone's radar, but it's also very important, especially for those of us concerned with property rights and civil asset forfeiture. The central issue in the case is the Sixth Amendment right to an attorney. The prosecutors would like to freeze all of the assets of a woman accused of operating a complicated Medicare fraud scheme down in Florida. This woman, Miss Luis, would like to use those untainted assets to pay for an attorney, as is her right under the Sixth Amendment. The government, however, has moved successfully to freeze all of her assets before trial, and would then, later on in the process, would like to seize those assets under asset forfeiture laws. So this is a case that poses important questions about the reach of the Sixth Amendment, as well as the reach of federal prosecutorial power, and what sort of limits the Sixth Amendment may place upon that power.